At the 2023 Fall Town Meeting, an article to fund a town centre reconfiguration passed by a narrow margin, less than 1 percentage point. A two-thirds majority, 66.6%, was needed and 67.4% voted in favour. 11 years prior, for an eerily similar article, 69% of town meeting reps voted in favour to fund a similar centre redesign. At that time, 11 years ago, George Similaris successfully ran a campaign to grant all registered voters in Billerica a chance to have a say. The town charter has a petition provision to keep the government branches in check. The petition resulted in a referendum which overwhelmingly overruled the town meeting vote, as documented in episode 1 of the Centre sequel, the 10th anniversary of George of the Centre. That 2012 scenario seemed to repeat itself last October 2023 until an October 26 Select Board meeting when 3 out of 5 board members voted to throw out a petition with 2,299 certified signatures. 3 so-called Democrat selectmen preferred oligarchy, government by a few, over democracy, government by the people. Reason enough for resident Dina Favreau to blow the whistle and spearhead a Superior Court case, the first hearing of which was at the Lowell Justice Centre, Room 16, on November 27, 2023, as documented in Episode 2 of the Centre sequel. The second and final hearing was on December 21. Next up is Episode 3 of the Centre sequel. All rise.
Court is now in session. The Honorable Patrick Hagan now presiding. You may be seated.
Good afternoon, Your Honor.
Good afternoon.
Judge, this is docket number 2381CV3241. It is Favreau et al. Versus Burrows et al. And it's a hearing for judgment on the pleading. Parties, please identify yourselves, starting with the counsel for the plaintiff.
Please support Attorney Lowell, the lawyer for the plaintiff.
Good afternoon.
Good afternoon, Your Honor. Deborah Ecker for the defendant. And with me is one of our associates, Maggie Crucial.
And Mark Rich, Town Counsel for the defendant.
Okay, good afternoon to you all.
Good afternoon, Your Honor.
All right, counsel, thank you for your accommodation and patience. I know we kind of move things along quickly, recognizing that this is an important matter for the town of Billerica and the parties involved. So we wanted to expedite everything. I know the parties kind of dispatched with the formalities of 9A, and I know the amended complaint was in fact filed, and it was allowed by me, and again, without objection by the defendants. So we're poised here, as I indicated previously, in a situation where we can hopefully resolve this case via judgment on the pleadings. I guess I do have one question for you, Attorney Millard, is that you did file in opposition to the defendant's motion for judgment on the pleadings, and then in your prayers for relief, you do ask that I issue the writ of mandamus. But I think, technically speaking, you're also requesting judgment on the pleadings. Is that correct? Okay, so do all the parties agree that all the evidence that I need to make this decision is within the documents that have been submitted, as well as the video, which was, for the record, was contained on a thumb drive that stopped working right at the interesting part of the Board of Selectmen hearing. Again, through no fault of any of the parties, I'm sure, but I just want to let all the parties know that I was forwarded a website by counsel for the defendants, which seemed completely accurate and legitimate of a website, and I actually watched the entirety of the Board of Selectmen proceeding from October 28th, was it? 26th, I'm sorry.
I have no objection.
No objection to that. All right, but does everyone agree that I have everything I need as far as evidence for the motion for judgment on the pleadings that both sides are asking for, and that neither side is requesting any type of additional evidence be submitted? Is that correct?
Yes, Your Honor.
Okay, you as well, counsel? Okay. All right, so let me just tell you what I have reviewed for cases. In that way, if you want to forward me to something else, I can obviously look that up. I'll be taking the matter under advisement today, although I do expect to make a decision relatively forthwith and soon. but I won't issue a decision from the bench today, but hopefully within the next few days. I did read the Perella case, as I thought it was particularly helpful for standing. I also reviewed a case that's not reported, but it's Bond versus Board of Selectmen versus Ashland, or Board of Selectmen of Ashland. And I also reviewed the case cited by Plaintiff's Counsel, Attorney Milliard, which was Robinson versus the Selectmen of Watertown. Obviously, I've studied extensively your memoranda, and I did look at a couple of other cases, which I don't have right in front of me. But obviously, I reviewed the town charter, in particular, section 2-13 regarding referendum procedures. I reviewed the minutes, obviously, from the relevant the town meeting, as well as, obviously, the minutes and the full video of the Board of Selectmen meeting from October 26th. So I do have a pretty good sense of all the facts, but let me start with hearing from defense counsel on the issue of standing. And I guess to be completely candid, I want you to try to convince me otherwise of where I'm leaning, which is, as I see the standing issue, and I think you both briefed it very, very well. It was very helpful, but no one's suggesting it's a mandamus is appropriate for standing except for the aspect of what's called the public right doctrine. And the way I view the case law is that the public right doctrine enforces a clear and unequivocal duty. And then the case law goes on to further explain that a clear and unequivocal duty is one that essentially does not have any discretion for the entity that's being challenged. So I guess I'll turn to you, counsel, as to why there would not be standing under that. And I was particularly moved by not only the Perella case, the facts of that case, which are distinguishable from what we have here, where in that case, the Turnpike Authority had significant discretion as to whether or not they had to do what was being requested there. And I also note the Board of Selectmen of Ashland case that I mentioned, Baum versus Board of Selectmen of Ashland, also had significant discretion. So why wouldn't that apply here, where there is very little, if any, discretion? Once again, the petition is submitted in accordance with that particular provision.
So that's the crux of the issue, right? So it's our contention that the duty, the first question that the court has to answer is whether the Board of Selectmen had the duty to review the purported petition, whether to accept it. That's a yes or no. Do we accept the petition? My brother in his opposition admits that someone has to review that petition to make sure that it complies.
But he suggests the town clerk.
Right, but that's not accurate. In a review of the charter, and in this provision itself. So the charter itself sets forth the clerk's duties and responsibilities. I believe it's 3-6, but also her duties, and it is she in this instance, her duties are circumscribed both by law, Chapter 41, Section 15, as well as regulation, 950 CMR, Section 55.02, and her duties are ministerial. What the clerk does, she is the record access officer. She has the information for those who are registered to vote, literally compares the signatures to those who are registered to vote. That's all that she does. There is nothing in the statutes or in the charter that gives her the duty or even any discretion whatsoever. And there's a case that we've cited to, not for that reason, but it's in our brief, I noticed, to determine whether substantively the referendum petition itself meets the terms of the charter. So it's that duty that we're focused on. And while the charter provision itself, Section 2-3, doesn't say who reviews it, there has to be a review, which is our point, that is axiomatic. I know my brother disagrees with that term, but someone has to review it because not all referendum petitions go before the Board of Selectmen. The request goes to them. They then look to see whether it fits in one of the categories that's not subject to a referendum petition or is in Section C, whether it's what was voted by.
Well, you mentioned the things that wouldn't include a referendum petition. Those you cited are in subsection A of Section 213, but none of that applies here. That's whether or not to vote to adjourn or dissolve the meeting and payment of notes. I mean, none of that applies here, correct?
That's correct, but my point in including that in addition, and we can get to Section C, particularly for purposes of standing, is that someone has to review it. It's not as if anything that comes before the Board of Selectmen, as a referendum petition, automatically goes to a vote. It is the board that then gets to determine. That's their duty, to determine whether it meets the charter. So they met that duty. It's not as if, in this instance, the Board of Selectmen didn't act. They got a piece of paper, ignored it, didn't put it on for a meeting, or the chairman decided not to put it on an agenda. They fulfilled their duty. They acted. And because they acted, it's not a proper subject for a mandamus petition. And plaintiffs wouldn't have standing, because what they object to is how they acted, their discretion.
Well, you say they acted and then there's no mandamus, but let's just give a hypothetical. Say that the referendum petition was exactly in the proper form. No one could dispute anything. And then the Board of Selectmen did similar to what they did in this case. It was a 3-2 vote, and they decide they don't want to send that out. So would that not be subject to a mandamus?
It would not be subject to a mandamus. They acted. I mean, obviously the court has the discretion in a lot of these cases, but here you can differentiate it from the other cases that have been cited, because in those cases, well, there was some action, and then it talks about the discretion, but you don't have, particularly here where the wording, and we can get into that after we get over the standing, you don't have a situation where, okay, it meets clear face terms of this charter provision, that the requirements, and they decided, nope, don't want to act, not going to do it. Instead, as you saw in the meeting, there's a spirited conversation, and they decided in their discretion that it didn't meet.
But we may be jumping ahead, and I think I know your argument on this, but where in subsection C do you see any language that would be indicative of discretion by the Board of Selectmen, or having to find the petitions in quote-unquote proper form, which I found interesting because you cited some Attorney General's language for certain referendums that can be turned over to the voters. And those were completely different than what we had here. Those were extensive paragraphs that laid out a certain form, and it specifically said that the Attorney General has to review the form to ensure it's in proper form, and then it goes out as a petition or referendum to the voters to vote on. Here, the only reference related to the Board of Selectmen is that they shall, within 10 days, call a special election to be held. And before that, there's nothing about it being in proper form. It just simply says if within 7 days following the dissolution of a representative town meeting, so we have that, a petition signed by not less than 5% of the voters, we have that, contain their names and address, is filed with the Board of Selectmen, requesting that any question as voted by the town meeting be referred to the voters for final determination. Then it says they shall. So under your theory, shouldn't there be some language saying if in proper form, or if accepted by the Board of Selectmen? There's no language like that, is there?
No, but it says in here that any question as voted by town meeting. So for example, even if it doesn't fit in one of the categories that's accepted, right, under A, what if there was a petition that was on something that wasn't voted on by town meeting? Would that have to go out to a special election, right? Or what if, as we contend, this doesn't say what town meeting voted on? Would that still have to go out to a special election? So there has to be some sort of, his term, gatekeeping as to what then gets put before the voters at large.
But isn't that covered by the later parameters that lay out exactly how the question should be presented to the voters?
No, because that would mean that then the selectmen have to rewrite, right? So let's say it was a petition that wasn't even close to what was put, not the financing of the town center project, but the financing of a bridge or something. Get all these signatures, it goes to it. Then what's the selectman to do? You're jumping over the step that it has to be something that's voted on by town meeting.
Okay. But, and I know I'm jumping around a little bit, but I do want to go back to the question I gave you before, which is my hypothetical. Again, let's assume everything is perfect. Your position is that the Board of Selectmen have the authority to, even though the word says shall, they can basically say, we disagree with what's provided in section 2-13 for a petition for referendum vote by the citizens. They can just outvote that.
Well, if the court reviews that, it wouldn't be reasonable, obviously, but for the standing question itself, there's some things that just aren't reviewable.
But you find shall to suggest some discretion.
Yeah, shall is, and there's case law on this, mandatory, it can be mandatory or directory. It's not always, shall you have to, but the shall you don't get to until you figure out if it's a petition they have to accept it first. It's a request to the select board. And the select board has to look to see whether that petition complies with the charter, is proper to put to the voters at large. And that's the initial duty, that review.
But it doesn't say in section C that review is done by the Board of Selectmen, does it?
But it does. If you read the charter, it certainly doesn't say it's done by the clerk. In fact, the clerk's not mentioned, right, in section C or anywhere in this referendum procedure. The clerk, because she's the record access officer, has that information to compare the signatures. And if you look at the letter that was sent that my brother attached to his opposition, all she does is certify the number of signatures needed to proceed. So it's not the clerk that looks to whether it's substantively the petition's okay. Literally, her ministerial function is to look at the signatures, make sure they're registered voters.
But if the intention is what you say it is, and again, I assume you would agree that we have to look to the intention of the town charter. If the intention was to have happen what you say happen, all it would have required is a simple phrase, not even a full sentence, indicating if determined in proper form by the Board of Selectmen, then they shall issue the referendum vote. But there's nothing like that in there, right?
Right, but you have to look at the charter and the intent as a whole, right? Because if you take yours to the extreme, the selectmen would have to accept any referendum petition except those contained in the categories, no matter whether it was voted on by town meeting.
Well, not any. It would have to be voted on by town meeting,
and it would voted on by town meeting, right? So when they looked at it, the select board, and you saw in the video recording, they said this is not the question that was voted on by town meeting.
Let's talk about that, though, because I am concerned about a little bit nuance and play on words. So it does include Article 14 in the petition, correct? It does.
It does.
And Article 14 does not even have, it states to see if the town will vote to approve the sum of 15 million, so on and so forth. There's no provision within Article 14 for there to be a vote by the town meeting as to putting it out to a referendum to the town. It's either yes or no. Either yes, you approve Article 14, or no, you don't. We know the yes has prevailed by 2 votes, correct?
So what happens, the article is what's on the warrant.
Right.
There is a motion at town meeting that's made. Motion to approve, motion not to approve. So it's the motion itself that's voted on. So the motion was to approve the funding for the town center and the rest of the stuff.
Right, so my question is, was there a third option? In other words, you either approve or you don't approve. And to me, this is important, because if it's either a yes or no vote on that question, the defendant's position that, well, it's all confused because if you read the language of what's in the petition, it makes it seem as if the town meeting voted to send it out to the referendum. And we all know that didn't happen.
And it can't happen.
Right, but I guess my question is, looking at Article 14, it couldn't happen. There's only a yes vote or no vote, correct?
There's a yes or no or abstain.
But it's not even possible to have a vote that would be sending it out for referendum.
Correct, and that's not what happened at town meeting, and that's what this petition says that the town meeting did.
But right, anyone who would read that would know that would be an impossibility.
Well, not necessarily. You and I know that, right? Now I know that from having to have read this. But someone who's, given a petition, if I had read this without knowing anything about town meetings law, I would have thought, oh, the representative town meeting, who represent, obviously, their constituents, voted, we're not going to decide, we're going to send it to the voters at large. Let's see how everyone in town wants, believes whether we should fund the town center project or not. That's what that says, that, instead of voting yay, nay to fund, we decided, well, it should go to the voters at large.
So if the petition simply said, petition to amend the action of the representative town meeting, it voted to approve Article 14 in the fall of 2023, period, and then had Article 14 underneath, would that be sufficient?
I'm sorry, I missed the first part.
If you look at the petition, it starts with petition to amend the action of the representative town meeting, it voted to approve Article 14 in the fall of 2023. What if that's all it said?
Yeah, to send it to the voters at large.
Then one would have to know what the town meeting had voted.
The town voted. So, for example, if you look at the ones that my brother attaches to his, taking aside the language of the amended, right? To send to the voters at large with representative town meeting where it voted to approve Article 10. It's that simple. It doesn't need to, I'm not sure where all this other verbiage came in or what happened, but all they're asking, all the petition is asking to do is to have the petition, the warrant as voted at town meeting referred to the public at large for a vote. That's it. But that's not what this says. This misrepresents the vote at town meeting. This says that if I'm a constituent, if my representative decided, well, I don't want to make that decision on your behalf, I want to send it to the voters at large. You all should be making that decision, which is not how a representative town meeting works.
Well, let's just break it down if we can. Okay, so it starts off with petition to amend the action of the representative town meeting, comma, it voted to approve Article 14 in the fall 2023 town warrant. Is all of that, if the period are right there, is that all accurate?
No.
The town meeting didn't approve Article 14?
The representative town meeting, taking out the amend, voted to, yes, approve.
Okay. And then do you agree that amend means something, amend means change, right?
Amend means change.
Okay. So that is a fair reading or inference that at least the first phrase that I've just read of this petition is asking to change the decision to approve Article 14. Do you admit that?
No, I don't. So they're asking them to send it out to the vote. What you have to do is send it out to the voters. So it's a motion that's made at town meeting where the representatives are to approve the warrant article. And then they voted. We have the vote. And then all this charter does, all they had to do was say, request that be sent to the voters at large.
Do you agree that the language at the end, which again is problematic, in a perfect world, that sentence that phrase should have been moved up front, but doesn't the petition just use the exact language from subsection C where they say, requesting any question voted by the town meeting be referred to the voters at large for final determination? That very phrase is verbatim included at the end here. Again, not in the best place for sentence construction purposes, but it says, to the Billerica voters at large in order for final determination as to funding of the town center.
But you skipped over the it, right? It voted to approve, right? You have to read the whole sentence. Article 14 in the fall 2023 town warrant to the Billerica voters at large in order for a final determination as to the funding the new town center plan. So it voted to have the voters at large make that determination where the vote at town meeting was to fund it.
But it says it voted to approve Article 14, and Article 14 doesn't say anything about sending it out to the voters at large.
Right, that's right. And this is what this says. When I read this, it says that what was voted on at town meeting by the representatives was to send Article 14 out to be determined by the voters at large.
Okay, so let's assume
versus town meeting voting to fund the project or not voting.
So what other logical interpretation could there be of somebody being asked to sign this petition? So let's take your argument at face value that someone would read this and would think, well, the town meeting approved sending it out to the community at large. Then what are they petitioning for?
For the selectmen to do just that. But that's not. But it misrepresents what the town meeting voted. The town meeting members did not vote to do that. They're petitioning under the charter provision to have the select board send to the voters at large something that didn't happen at town meeting.
Send to the voters at large to vote whether there should be a vote at large? I'm having trouble understanding that.
So what happened at town meeting, and I think I've said this, right? The representative town meeting voted on Article 14, the motion to approve or not to approve. They approved the funding. This says that what was voted on at town meeting by the representatives was to have this article sent out to the voters at large. And that's not what was done at that town meeting. And so it's not what was voted on by town meeting as set forth in the charter.
But wouldn't your argument be better if it didn't include the actual text of Article 14? In other words, if a voter read Article 14, they would know that there's no option to send this out to the town voters at large. It's basically yay or nay.
Well, no, because the question is the motion itself at town meeting, right? It's the motion. We talk about pleading notice in the opposition. The warrant article is posted before town meeting, and so that's notice to those of what's going to be voted on, but it's the motions themselves. Yes, they see what the article is, but what they're requesting up top is not accurate as to what occurred at town meeting. That wasn't the motion that was made.
Do you agree that the simple placement of a comma would make it more clear, or a period?
No, honestly. Well, no, I mean, could it be drafted better? I'm not sure. It's just a comma, and that's not what was said at you watched the video. I think that the simple would have made it easier if you just keep it simple, right? We request the select board send out to the voter at large the approval of Article 14.
Okay. All right. Anything else from your perspective?
I lost my train of thought.
No, I know we started with standing, and we've kind of moved to the big picture.
I do think the initial question that has to be answered is whether the Board of Selectmen, the Select Board, had the duty to review and the obligation to review the petition prior to accepting it. If Your Honor, it sounds like you will, finds that they did or didn't, whether that decision was reasonable. And we cite a case law that the court should defer to the Select Board itself in making those discretionary decisions. And in this case, again, I won't beat a dead horse. I've told you why I think it's reasonable, and that this is inappropriate for a writ of mandamus because they did act on their duty.
But what if I agree with you that the Select Board did have an obligation to at least review the petition and make sure it complied with what was required under the section? Wouldn't I just find that the obligation of the board is to find out if it was a petition signed by not less than 5% of the voters? It was at least it was prior to 7 days following the dissolution of the town meeting. It contained the names, and it requested that any question voted by the town meeting members. I mean, if that's all they have to approve.
No, because you said Section C, right?
Yes.
Yes, that is what they have to approve. Or if it's in one of the categories.
And your argument here is what they had a problem with was the last one, that they couldn't certify that it was requesting a question voted by the town meeting members be referred to the voters at large. Is that what your position is?
Our position is, it is under the charter, it is not a question that was voted on at town meeting, and so it's not a proper petition.
Because your argument suggests that the town actually voted to send it out to the voters.
Correct.
The town meeting did.
Correct. And that's not the question that was voted on by town meeting pursuant to Section 2-13C.
But ultimately, your argument is even if it did properly state all that, the Board of Selectmen still had the authority to have a vote and decide whether or not to comply with that particular part of the charter.
Yes.
And you base that on what? What's your best case for that?
What is my best case for that? I don't know off the top of my head, Your Honor, but I mean, boards do this all the time, right? And so then the question is there a mechanism, not all the time, but is there a mechanism for review? And what that mechanism is, a mandamus is an extraordinary remedy. And all things that are done by select boards are not necessarily reviewable.
And I think this is your position. I know this was argued during by your town council during that rather contentious select board meeting. It seems to be that there's an implied duty within this language where the select board has to approve this in some manner, and that you could infer from the language of the provision that involves obviously a vote of the 5 selectmen, and they have to decide whether to put this out. But your attorney even conceded that that's not in the actual provision, but it's implied or inferred. Is there any case that would help me on that, or case, or even another similar provision? And the reason I ask that is because when I read your brief, and you get to that part where you're trying to argue that this is obviously an inherent authority of the board to do this, you then cited that Attorney General's situation. And I thought I was going to look at that and see a similar, I mean, we can all agree it's a very vague provision. It doesn't give a lot of details, and it uses the word shall and doesn't seem to have any proper form language or discretionary language. But I was hoping to see another similar situation where the courts or entities such as the Attorney General's office found that there was an implied authority to give the board some discretion on whether or not to allow this to go out. And I didn't find that in the Attorney General's case. Like I said, if anything, I saw 5 paragraphs of extensive detail as what would be required, and having the words, the AG had to find it in proper form. Do you have anything that you could point me to that would be similar to what we have
I
here?
don't, other than common sense, Your Honor, right? So all the cases that are cited talk about a review of these initiative petitions or referendums in the case of the towns before putting it on. And so they're all fact-specific, specific to the language contained in their respective charters, but also using common sense. Someone has to review it. Someone has to. My brother agrees. Someone has to review it. He says it's the clerk. We said by statute, they have very limited role. And so because the request is being made to the board, it's a request to the board under this referendum procedure, it's the board who first has to decide whether to accept it.
Does the Section C doesn't use the word request though, right? It says submitted to the board.
So
I mean, there's no word request. And it says once it's submitted, shall.
it says, so is filed with the Board of Selectmen requesting that any question is voted by town meeting members be referred to the voters at large for final determinations. So they're requesting it.
But they're submitting it, requesting it.
Well, they're obviously
Sure.
submitting
Okay.
it, right? But they're requesting it. And so then the select board looks at the request. Is this proper? Should I accept it? Here, you saw the spirit of discussion that went on. They decided no. And so they acted. They voted because it was not the question is voted on by town meeting.
And then the people who sign a petition have no recourse. In other words, the 7 days is up and they have no recourse.
Yes. Not everyone has recourse in court.
But if that were the case, wouldn't there be some provision in there that would say, should the Board of Selectmen deem the petition to be non-compliant in proper form, it could be resubmitted within another 7 days? In other words,
Not necessarily. I mean, that's a good suggestion, but not necessarily. There are a number of articles or authority that the Board of Selectmen has that's just not reviewable.
Council, what do you say about the Robinson case versus Selectmen of Watertown? It did seem to be very similar here. I know it's a 1950s case, but when I looked at it, it seems to be good law that was cited by council, and it seemed to have a very similar provision to what we had here.
But that also, in that case, they reviewed the language first. It's not as if they said, okay, we have it, we're going to vote. There was a specific, in looking at the language and the fact pattern, that they determined it wasn't a proper subject for the voters. They had to review it first to make that determination one way or the other, if I'm looking at the correct case. You're looking at me quizzically.
Okay. No, I think you're right. Okay.
So it's that review process that the Board of Selectmen did, as you saw at the hearing.
Okay. All right. Anything else you think would be helpful that you think I should look at before making a decision?
No, but I'd like to hear what my
Sure. No,
brother has to
I'll
say.
give both sides as much time as you need. Okay, Attorney Milliard.
Flashback to my classes in law school where somebody mentioned common sense and being that, ladies and gentlemen, we're not here to learn common sense, we're here to learn the law. Starting at the beginning with the gatekeeper, there's very little gatekeeping going on here. What the defendants in this matter have failed to address, what if the petition is submitted in more than 7 days? Would the clerk not be a gatekeeper and say, here are your papers back, it should have been here within 7 days, it came here beyond 7 days? Gatekeeper, she doesn't have to submit it. I certify the signatures, you don't have 5%. Is she going to turn it over to selectmen? No. Even Thomas Jefferson didn't reinvent the wheel with the Declaration of Independence. He borrowed from Locke and Rousseau, and I would suggest to the court that the people who drafted the Billerica Town Charter also borrowed from other entities and other statutes that were available. In Robinson, I cite in my memo, the 1948 state statute, except for the percentage of signatures required and the time frame, is almost the same as their charter. The same thing in Morway towards the end of my memo, Morway versus Town of Webster, the same. In Mass General Laws, Chapter 43, Section 42, it has to do with cities and referendum, either to a school committee or a city council. changes the number of people that have to sign, and it changes the time frame, but it allows the clerk to schedule the election. But then there's language in there that says, filed with the city clerk, the same shall thereupon and thereby be suspended, shall immediately reconsider such measures. The city clerk shall submit the same, provided the vote of the registered voters either at the next regular city election or at a special election which the city council may, in its discretion, call for the purpose. So I would submit to the court that when the Billerica Charter was being looked at, and
They could have put that in, is your point. They could have put in within the discretion
they could have put in discretion. I would suggest to the court that this is exactly in keeping with American system of government from the very earliest days of the Republic. They want to make the people sovereign, and there is a fail-safe measure here for a town meeting, and that is this referendum process. And they don't want the selectmen, and nowhere does it say, quote unquote, they have not been able in their argument or in their memo, have they been able to provide the court, quote unquote, the selectmen shall review the petition for sufficiency and adequacy.
But in fairness, similarly, it would have been better if subsection C said, if so certified by the town clerk. In other words, it lays out the requirements, then says, so certified by the town clerk, then submitted to the Board of Selectmen. The Board of Selectmen shall convene a meeting and schedule a referendum. I mean, that would have been better if that were added, right?
That's true, Judge. However, I would suggest to you that there was a saving factor here, and that is the entire warrant article was reproduced on the petition, the entire warrant article. So the language on top is simply their argument that the people didn't know what they were signing. Well, here, you can read the warrant article for yourself. Furthermore, I am reliably informed town meeting is televised. So people could see town meeting and hear what was going on and be aware of it that way. Anyone signing could see what was going on. In the Morway case that I cite here, Morway versus Webster, the court felt that 1,000 people signing was enough to make the matter go forward, that the select board should have scheduled the election. Here we have almost 3 times that many people signing. The case, especially the Swift case, which is cited with approval in Morway, it always goes in favor of the voter and the voter exercising the franchise. And that's exactly what's going on here. That's the purpose of the charter, that ultimately sovereignty in the town of Billerica rests with the voters. It does not rest with 3 select board members who say, we know better than you, you didn't understand what you were signing. And in furtherance of that, even though this has been going on now for roughly 2 months, there is not a single affidavit, a single statement, or a single person willing to appear at a hearing here saying, yeah, I signed that and I was sandbagged. I didn't know what I was signing. They have none of that, even though it has been reported in the press and it is the subject of social media in the town, what the argument has been. Not a single person has come forward to say, I didn't know what I was doing. But 3 members of the select board say, oh, we know, you didn't know what you were doing. Well, 2 members of the select board did know what was going on, and they voted to allow the election. We have notice pleading, and have notice pleading since 1938. We got rid of the hyper-technical fact pleading where a mistaken word, a mistaken comma was fatal to your pleadings. Now, a good faith notice putting you on notice of what the claim is sufficient to get over the hurdle. Here, it is crystal clear what these people want. They want this Article 14 on the ballot subject to a special election. It's not asking to change the name of the main street in Billerica. It's not asking to annex one of the precincts in Wilmington. It clearly and fairly puts on notice, and at least 2 of the members of the select board got that, what the purpose of this petition is. To rely on the hyper-technical interpretation that the defendants are urging on the court is completely opposite to our current practice on pleading and to the current and to the intent of the charter and the form of government we have. These people want to vote. The cases I cite in my memo make clear the law is in favor of the people voting. 2 of the selectmen in the video the court watched gave a very impassioned plea about the people being able to vote,
and why the other 3 would not allow them to vote. I don't make any comment on that.
Do you concede, though, Attorney Miller, that again, hindsight being 2020, the wording of the petition is somewhat poor? In other words, had it not included Article 14 exactly what it was, had it simply said petition to amend the action of the representative town meeting, it voted to approve Article 14, town warrant to the Billerica voters at large in order for final determination as to funding of the new town center plan. That's a little confusing. That could be interpreted to mean that the town meeting had actually voted to put it out to the...
I'd have a rougher road to hoe. However, the saving grace here
is the attachment of having Article 14 in there.
Is this, well, even more to the point. Paragraph C of 213 says the ballot has to fairly and accurately represent the warrant article as was presented to the town meeting. It makes no mention at all of what the statement requesting the board to schedule the special election has to say. And in my memo I submit to the court a simple, we the undersigned ask the board to schedule a special election relative to Article 14, which was passed at town meeting on, I believe, October 3rd, 2020. That would have got over the hurdle. The only time, and the defendants conflate these issues in their memorandum, the only time it has to be apple pie perfect is when the ballot is printed. And that is in the clear and unambiguous language of the bylaw. Otherwise, simply a fair notice to the select board, we want this on the ballot, we want you to schedule a special election. That gets you over the hurdle. Whether there's a comma here, no comma there, how that language, as long as they are on notice as to what the intent of that petition is, that gets you by. If they wanted them to pass on the sufficiency, I would suggest to the court that would be in the bylaw. If they wanted them to have any power other than to take out their calendars and schedule the election, that would be in the bylaw.
But what do you say, though, counsel, to the point that there has to be actually reference to it, something that was actually voted on? In other words, you couldn't get a petition with 3,000 votes saying the town meeting voted to increase the salary of the town manager by $100,000 when that was never done. That wouldn't have to be sent out to the voters, right? You can see that?
Well, I would agree with that, Judge, but I would also say that there's a provision in there where at the very beginning of the bylaw and throughout, though my sister and I disagree on what the exact authority of the clerk is and what her role is here, I would argue that the clerk would say, well, that's not one of the ones that we can schedule, so even if you submitted it in under 7 days and you got 5% of the registered voters, that isn't going there because it does not comply. The town charter gives the clerk the sole gatekeeping function, and it is a very limited one. Is it subject to a referendum petition? Yes. Was it submitted in under 7 days? Yes. Do you have 5% or more of the registered voters? Yes. If there's an upcheck in all 3 of those boxes, gatekeeping's done. Here's selectmen.
Wait, you're forgetting the last box that has to be checked, though. It has to request that any question voted by the town meeting members be that's another requirement. You agree with that?
Correct.
So are you suggesting that the town clerk had the right to do what the select board did here? And the town clerk could have said, you know what, this is very poorly written and it's a little confusing. I'm going to reject it. Could she do that? Or she, I think in this case.
I don't know, but I would say that if she thought she had the authority, she exercised it in favor of the petition's good to go and sent it to the select board, which triggered their one job. As they say in American pop culture, you had one job to do, which was schedule the election. And instead of doing that, you opted to give the town an English lesson and to lecture the town about their ability to understand what they were signing. And that is nowhere in the charter. Nowhere does it say that they get to lecture the town about whether they understood it. Nowhere does it say they get to pass on the language. Their only function is to schedule it once it gets past the admittedly very low bar gatekeeping of the town clerk. That is their only function. Schedule the
So your position as a select board has no discretion whatsoever. They're not even doing the ministerial gatekeeping aspect. They're simply, if it's submitted to them by the clerk, they schedule the town vote.
I was pretty stunned by that. By looking at it, I thought, isn't there anything here about they get to review or something? No, there isn't. And unfortunately, I can't read something into it that isn't there. If they don't have that, they are given a job, a shall schedule the election. They don't even have may rule on the validity, may send it back, may ask for an advisory opinion from town council. None of that is there. They have one job only, shall. And so I would take it at face value that the town charter committee, when they reviewed and issued the 1973 version of the town charter, must have considered all the options, especially when one looks at the language of the statutes from other cases, and except for minor changes like the number of days involved and the percentage of voters that have to be involved, some of them, they give them the authority, some of them don't. The statute I quoted here, may at their discretion scheduling. I would suggest to the court that they must have reviewed all their choices. This is the one they came up with. And what they came up with is, if we get 5% of our people to sign off on it, there are enough people here that you have to do it. And Judge, a part of the statute, a part of the charter bylaw that we're not considering here is, that's still not a good deal. Because when the ballot is printed, the ballot has to mirror the language the moderator gave the representative town meeting. Then when they vote, if they get a simple majority, then they win. On the other hand, regardless of who gets a simple majority, if 20% of the voters who voted in the prior town election do not turn out, the representative town meeting decision is upheld. So there is a built-in safeguard within the charter, which is perhaps why they didn't have the selectmen review it, because not only do you have to win, but you have to win with at least a 20% turnout of the prior town election. So a simple majority in and of itself is not going to carry the day. It has to be how many people turned out to vote. And if you have fewer than 20%, then Article 14, which was approved by 2 votes at the representative town meeting, will stand.
So your relevance to that point is that the fact that there's this additional safeguard that would still affirm the town meeting vote suggests that had the drafters of the provision wanted it to be so, they would have put in the, if there weren't that extra safeguard, they'd be more likely to put the additional gatekeeper function of the select board.
Which I submit to the court is yet more example of how they wanted the Billerica voters to be sovereign in their own town. Because if you're not interested enough to turn out and vote, then the representative town meeting will be upheld in its decision. And that is what they have decided to put in their charter.
Okay, anything else, Senator Miller?
No, Judge.
Okay, counsel?
Sure. Let me just start on that last,
Sure.
just on that last point very briefly. The vote is in a majority, but it's not relevant here. But the point is that the voters are represented. It is a representative town meeting. They vote for those representatives, and presumably those representatives are voting on their behalf. So it's not as if we're disenfranchising voters.
Well, I get that, but there is obviously there's an exception provision, and it requires many things be done to get there. It's an exception, not the norm. I know representative government. I remember the argument about that during the select board meeting.
So then the gatekeeper. So when my brother says we're reading into the language of the charter, there's nothing in that charter that gives the clerk, as I've said, any responsibility or duty to look at the substance. And in fact, the clerk did not do that. Attached as Exhibit D to the opposition is what she did. And all she did was notify them that the petitioners have been checked to assure the signatures are those of registered voters in the town of Billerica, and she certified 2,299.
But you agree, she's the only one who could do that. In other words, she clearly had that duty. In other words, the Board of Selectmen or Select Board couldn't do that.
Right, and by statute. She has that information. Right. That's what she does.
Okay.
That's what she does. But that's all she does. And that's all her responsibility. And I've given you the statutes, the regulations. The substance, again, as I said, is a request to the Select Board. And the issue is the wording, again, I know I might be beating this to death, but on the petition itself. Is it something that was voted on by town meeting? And that's a requirement of Section C. What appears here is not what was voted on by town meeting. And that's what the Board of Selectmen, majority of them, and sometimes we do have 3-2 votes, that's their vote. That's what they determined.
Well, just to be clear, it does state town meeting voted to approve Article 14. So that was voted accurately by town meeting.
But it says it voted to send it to, I'm missing my wording, but it voted to approve Article 14 of the fall 2023 town warrant to the Billerica voters at large in order for a final determination as to funding to be made. So, as I've said, it sounds to me, and it reads, that the representative town meeting voted to send it to the voters to make that decision whether to fund the town center project versus we vote to fund the town center project and the rest of what was in Article 14.
But would you agree that another interpretation of that, someone could read that and realize that they're just using the word of what has to be done on a petition, and that when they say in order for final determination as to funding of the new town center plan, voters at large, that they're referring to what they're asking for, petition for. In other words, had they moved that up in the paragraph, petition for Billerica voters at large in order for final determination as to funding of the new town center, and then referenced Article 14.
Well, it's not the question as was voted by town meeting. I mean, I maybe petitioners did, I don't know, but it's not what was voted on by town meeting. That was not the question, whether to send it to the voters at large.
Okay. All right, anything else from your perspective?
No, Your Honor.
Attorney Miller, anything?
Judge, I just quote from my memo. In situations such as this, quote, every rational intendment is to be made in favor of the rightful exercise of the franchise. That principle pervades and dominates all our decisions and harmonizes them all. Swift v. Registrars of Voters of Quincy, 281 Mass 271 at 277, and that is cited in Morway, which I believe is a 1990 case. So,
okay. All right, whoever argues last does not necessarily win, but if anybody else wants to point to anything else, I'll let you do so. Anyone? Okay, I think the briefing was very helpful. The arguments were very helpful, counsel. And again, as I know this is an important matter, I will try to get a decision out as quickly as possible, but I will take that under advisement. Anything else we need to discuss, counsel? All right, thank you all very much.
After having taken the matter under advisement, Judge Hagen's decision was made public on January 10, 2024. His ruling ordered that the defendants as members of the Billerica's Board of Selectmen schedule a special election in accordance with the town charter for a final determination of the question presented in Article 14 of the fall 2023 town warrant. The Select Board unanimously set the special election date for Saturday, February 17, with early voting at Town Hall on February 12, 13, and 14, Valentine's Day.